I'm Deborah Embach. I'm here with attorney Aaron Feldman, and we're going to talk about some community property issues today.
Thank you, Deborah. And, community property comes into estate planning and probate in a number of different ways. So we thought it'd be a good idea to talk about some of those issues this afternoon.
And can you start by telling us whether assets qualify as community property versus separate property?
Sure. So community property is broadly defined in California as property acquired during the marriage. So that would include earnings during the marriage or property you acquire with community funds during the marriage. Separate property would be something that is either a gift from somebody else or an inheritance.
Great, great. And now looking at a spousal property petition, what distinguishes that from a full probate proceeding?
Well, a spousal property petition is a claim by the spouse to a share of community property. So when somebody dies without a will and there are assets that are community property, a spousal property petition is a way to quickly have those assets confirmed as community property assets belonging to the surviving spouse without the need for a long, drawn-out formal probate.
And how do courts determine what is community property in a spousal property petition?
So when we file community property petitions, we have to offer some facts or evidence that would support that there could be no other source for these funds other than through the efforts of the community, meaning earnings during the marriage. Recently, we have a case involving some bank accounts, and the court asked us to provide proof that the decedent didn't have assets that they brought into the marriage as separate property, and other questions like that to confirm that these are in fact community property assets belonging to the surviving spouse, as opposed to assets that in an intestate probate might belong partially to the spouse and partially to other heirs, such as children.
Okay. And how do creditors' claims and outstanding debts affect the outcome of a spousal property petition?
So there is no creditor claim process in a spousal property petition the way there would be in a probate. So there are no creditors' claims to address in the spousal petition itself. However, as a general proposition, there are community debts, and the surviving spouse could be contacted by creditors if there are separate debts. Most spouses know, for example, if there's a credit card, their both names are on it and things like that. So it's not a situation of the creditors having to look for somebody like an executor of an estate for payment.
Mm-hmm, mm-hmm. And how do variations in state law impact the availability and process of a spousal property petition, particularly with community property states versus common law states?
Well, we are California lawyers. And so when we file either a spousal property petition or a probate, we are only dealing with California assets and California law. However, that being said, sometimes there are assets outside of California that we need to open ancillary probate proceedings, in other states and hire other lawyers to help us do that. And again, if they're domiciled in California, the other states should accept that California law applies to those assets.
And what are the long-term legal and tax implications for a surviving spouse who acquires property through a spousal property petition?
The legal implications at the end of a spousal property petition, there is an order that confirms the community property interest and awards those assets to the surviving spouse. So in the example, if it were real estate, you would have to record the order with the legal description to confirm that as belonging to the surviving spouse. As for the tax implications, it is possible that there is a partial step up in basis And therefore, if the asset is sold during the surviving spouse's lifetime, it may lessen the capital gains that may apply to that asset. But in any situation like that, you should consult with a tax professional rather than legal advice on that matter.
Sure, sure. And finally, what strategic considerations should an attorney weigh in deciding between filing a spousal property petition and a petition for probate?
It really comes down to facts. And so the way a good attorney will handle the situation is to ask questions and draw out information, because it is always going to be tactically advantageous to be able to apply a spousal property petition, which might take 3 months to complete, versus a probate that could take 18 months. And there are examples where we have been unable to use the spousal property petition process because the information is just not clear on whether that asset is truly community property, and therefore we end up having to go into the probate process. But it is something we try to avoid if the facts allow.
Absolutely, absolutely. Are there any other considerations or things you would like to talk about regarding community property?
There is one other area of community property that is affected in this area, and that involves transfers of community property without spousal consent. And it's a little esoteric, but basically, under California family law, you cannot give away community property without your spouse's consent. And we have run across situations where that has occurred. For example, in somebody who knew they were dying wanted a child to receive assets upon their death rather than having it go to the surviving spouse. And so they opened up a joint account with their child and put community property money into it. And in those situations, you can go into court and void that transaction. And we've done that in several different circumstances when it applies.
An important circumstance to keep aware of. Thank you so much for your time.
All right. Thank you, Deborah.